Hello there, I'm Lloyd Evans and you're watching the John Cedars channel from the bunker, and in this video I will be giving my commentary on what we saw at the first day of IICSA's investigation into child protection in religious organisations and settings. I've already explained the nature of this investigation and indeed the nature of IICSA in the previous video in this series, part 2. So if you're unfamiliar with what IICSA is and what it's about, what it's doing, please first check out part 2, and that will avoid any need for me to repeat myself. It is worth noting, as I mentioned in a very brief update video, that these hearings have now been postponed. So we got the first day of what was intended to be 10 days of hearings, and then it was declared that we couldn't continue. We have to wait until some point in the future when these hearings continue. But of interest to those who follow Jehovah's Witnesses, and indeed Jehovah's Witnesses themselves, I guess you would have this day in particular where opening statements are given, including an opening statement by a representative of Jehovah's Witnesses, which we will get to. You also would have had Thursday the 19th, so we're now talking about what happened on Monday the 16th. Thursday the 19th would have been the day dedicated to hearing out all sides of the argument when it comes to child protection in Jehovah's Witnesses. Again, that day has now been postponed, and I guess with those 2 days out of the way, you then would have had the conclusion of the hearing when all of the core participants would have given their concluding statement. So that's really 3 days in total that are of interest if we're focusing on Jehovah's Witnesses. I was supposed to be getting on my flight today to London to join the inquiry. Obviously I don't need to do that now, so I can instead sit down and forensically go through everything that was said that was relevant to Jehovah's Witnesses. So from 4 hours of footage, not including a witness statement that was given towards the end of the proceedings, which wasn't to do with Jehovah's Witnesses, from 4 hours I've managed to whittle it down to 45 minutes of material relevant to Jehovah's Witnesses. So we'll be hearing from Fiona Scolding, whose job it is to basically question all of the core participants and basically act as the lawyer for the inquiry in its investigation. Then you have statements from my lawyer, Richard Scorer. You have an opening statement from Sam Barker, who is the lawyer for the XJW Advocates Group. We will have a statement as well from Shane Brady, who is the Mr. Fix-It lawyer, as I mentioned in my previous video. He's the lawyer for CCJW, which is the legal entity that Watchtower prefers to be identified as for the purpose of these hearings. He's going to be giving his thoughts on Jehovah's Witnesses, and as I'm going to explain later, I think it's useful to contrast his comments with comments that were given by representatives of other religions that are being considered in these hearings, because obviously Jehovah's Witnesses are just one of many religions under consideration. What kind of attitude and what kind of approach have other religions taken when their child protection policies are in the process of being scrutinized? So that's going to be very interesting to take a look at. Before we launch into the opening statement by Miss Scolding, I thought I would just play you this brief clip.
I would At this stage, I would like to emphasise again that throughout these hearings, core participants should act with civility and respect towards everyone involved. This means that all core participants should choose their words with care when making submissions or giving evidence, and avoid use of language or statements which are offensive or inflammatory.
So I've chosen this clip for two reasons. First of all, I just found it quite interesting when you had that sneeze at the end, because you can kind of see anxious looks on the faces of some of the staff, some of the IICSA staff in the foreground there. Maybe the fact that there was coughing and sneezing going on in the hearing room itself during proceedings, maybe that could have influenced to some degree the decision to postpone the hearings. Who knows? But I also think it's interesting that Professor Alexis Jay, who is the chair of IICSA, has stressed this point about the need for respect and civility and not making offensive comments. I think that she's doing this because, I mean, obviously I hate to speak for Professor Jay, but it seems that she is recognising that there's a bit of a tinderbox in front of her, because you have religious groups and you also have survivors of abuse or representatives of survivors of abuse within those same religious groups. When we're dealing with child sex abuse and with the profound effects that that abuse can have, there's so much potential for feelings to run high and for very direct, very cutting language to be employed. And I don't blame Professor Jay for trying to keep things as civil as possible. And I agree that we can only really move forward in a meaningful way if we temper our words as much as possible. So try as much as possible not to reach for hyperbole, not to exaggerate. Try and keep things as accurate and professional as possible. It seems for the most part that's what happened during this day of hearings. I would just point out, though, that if something is said that is factually incorrect, if something is said that is frankly a lie, then not only are the hearings themselves being disrespected, but potentially if the lie is, for example, on the part of CCJW, on the part of Jehovah's Witnesses, then survivors of abuse are being disrespected as well, because their experience is being disparaged and denied. So I guess what I'm saying is it runs both ways. And while it's easy to think of invective and ad hominem and insults as an example of lack of civility and lack of respect, I would point out that it's also possible to be disrespectful simply by lying, and also by saying things like, which, and this example doesn't appear in this hearing, but I'm giving you one example. If it was said, for example, by Jehovah's Witnesses that being part of the religion is a personal choice, and it's also a personal choice as to whether you leave or not, completely disregarding the fact that people who join the religion do so believing that Armageddon's coming and they'll die if they don't join the religion, and ignoring the whole issue surrounding shunning for those who leave, it's also possible to disrespect survivors of abuse with that sort of language. I just wanted to plant that flag there. And also, I should just acknowledge a quick disclaimer before we get into the opening statements. Again, as I said in my previous video, I'm a core participant in these proceedings, and therefore I know a lot about the arguments from both sides that I simply cannot talk about until it becomes public knowledge. So there's a few things that are said in these hearings that are finally made public knowledge and that I can say a little bit about, but only in so far as I'm not adding to the information. So I can comment on what's said. I can't add to it. I can't say, oh, and there's also this you need to know about. So I'm treading a very fine tightrope in making this video. I hope you will understand that. And if something gets missed out, it's not because I'm hiding information. It's because I am literally banned from sharing information. So with all of that out of the way, let's proceed with some clips, some relevant clips from the opening statement that was given by Miss Fiona Scolding QC.
We have accounts of abuse, as I've already identified, as part of the work of the Truth Project. It published a report about those who had come forward to it to speak about their experiences. It must be noted that most of those experiences, as recounted in the report, took place before 1980 and therefore are not current. 183 individuals have spoken to the Truth Project who had been sexually abused by either religious staff or within a religious organisation. It must, however, be stressed that in line with the English population, most of those cases related to the Church of England and the Catholic Church. Of other religious organisations, around 11% of those who have spoken to the Truth Project were members of the Jehovah's Witnesses.
So this is a really interesting point, and it's a point that we're going to return to in some of the other opening statements. Ms. Scolding is referring to the Truth Project report, which is a report that was commissioned by IICSA. 183, I think it was, people participated in the report who were survivors of abuse. And of all these participants, when asked what is your religion, the most cited religion apart from the Church of England and the Roman Catholic Church was Jehovah's Witnesses. 11% of participants said we were abused in the Jehovah's Witness religion. That is, if you think about it, horrifying, because Jehovah's Witnesses are not by any stretch the third biggest religion in England and Wales. They are a tiny religion compared to all of the other religions. If you think about Judaism, Islam, various other Christian denominations, Jehovah's Witnesses are tiny, and yet they account for the highest number of participants outside of the biggest two religions in the country. That is not to be glossed over. And if you think about it, there's a parallel here with the Australian Royal Commission. With the Australian Royal Commission, they kind of opened with the headline, look, we went after the records from the Australia branch and we found that there were 1,006 perpetrators of abuse going back to 1950, and not a single one had been reported to the authorities. And that alone said so much. It spoke volumes. And while this revelation from the Truth Project isn't quite as much of a bombshell as that particular disclosure in the Australian Royal Commission, it is nevertheless a very damning statistic for Jehovah's Witnesses. You do not want to be the most prolific organisation in terms of instances of abuse outside of the Roman Catholic Church and the Church of England.
Many organisations told us that they do not collate statistics centrally about the number of allegations within their churches or places of worship. As part of this investigation, therefore, we can do nothing more than to provide an extremely caveated and very small picture of those allegations. We can therefore say that Chabad Lubavitch, an organisation which provides community activities and outreach work to both the Jewish and non-Jewish community, and which runs a number of schools, has identified 8 allegations over the past 10 years, 6 of which, in fact, relate to the schools that they run. The Christian Congregation of Jehovah's Witnesses has identified 67 allegations being made to them, of whom 13 people were convicted of criminal offending. By contrast, the Baptist Union could not provide us with any reliable statistics because it does not collate those figures.
Now, I've got to be so careful here. I mentioned the tightrope earlier that I'm walking in making this video, and this is the most precarious part of the tightrope for me, because I know about I know a bit about what's being talked about here by Miss Scolding. What can I say? Miss Scolding notes that most religions don't seem to be keeping centralized records about instances of child abuse, and therefore the inquiry has to be very careful in drawing firm conclusions and must caveat its conclusions with the fact that it doesn't know the full extent of the abuse. It simply cannot be said that this applies to Jehovah's Witnesses when you have documented proof in the organisation's own publications, specifically the Shepherd Book, that every instance of abuse gets reported to the branch and records are kept. So I appreciate Miss Scolding will have had limited time. She'll be trying to get through as much information as quickly as possible, but the caveat that you might justifiably apply to other religious groups that don't keep those sorts of records simply cannot be applied to an organisation that openly says in its advice to elders, we keep these records. We absolutely keep all these records, and we'll be able to produce any record that we need to if the circumstances demand it. I stress this point because both myself and the other XJW core participants group made it very clear in the preliminary hearings that we wanted IICSA to use its powers in the same way that the Australian Royal Commission used their powers, and we made it clear that Watchtower should have been made to produce their records in the same way as happened in Australia. So far, IICSA doesn't seem to have done that. I think that it's unfortunate to say or to suggest that IICSA is limited in the extent to which it can understand the prevalence and scope of abuse. When it has that power, it's just not acting on it, or it's not applying that power despite being directly asked to go after the records by both myself and the other XJW advocates group. I obviously don't blame Miss Scolding for that. She is presenting the information that's to the best of her ability, and again with huge time constraints, no doubt. But I just wanted to plant a flag there that you can't really say, well, we're limited in how much we can understand the scope of abuse, when you are dealing with Jehovah's Witnesses in particular, which have, again, this policy of keeping as much data as possible on child abuse. The figure is also mentioned, 67 cases of abuse in the last 10 years, 13 of which resulted in criminal convictions. There are two things I would say there. First of all, we're not being told what, if any, percentage of those 67 cases of abuse were reported to the authorities so that they could be criminally convicted. And we're also not being told whether there were any limitations put on the numbers that Watchtower could divulge. So, for example, it could be that these 67 were selected due to certain parameters. I'm putting things as carefully as I possibly can, but you understand what I'm saying is it could conceivably be more than 67, but Watchtower has been allowed to limit the numbers in some way it would have been nice to get more clarification as to whether that has happened. And I'm hoping that as the hearings continue, more light will be shed on that particular statistic.
PRA 7, to give one example, tells us of her sexual abuse by an elder in the Jehovah's Witnesses congregation in the early 1990s, from the ages of around 12 to 14. She told her parents. They then told the elders of the congregation. She then had to, she says, as a teenager, meet both with the elders and with the perpetrator and his wife, the elders asking him what he had done to her in front of everyone. She also had to recount her story to a number of other elders, all of whom are male, but no action was then taken.
Right, so we're now in a part of Miss Scolding's statement where she's talking about survivor experiences, particularly witnesses who have come forward to IICSA with their stories, and one of these stories is that of PRA 7, and how horrifying as a teenager to be forced to confront your abuser. Now, what Watchtower would say to this is they would say, well, this story can't be treated seriously because we actually have in our policies a rule that says a victim of abuse should absolutely never be required to confront their abuser. Well, that's fine. You can have that policy, and I obviously applaud you having that policy. But what about the time that you didn't have that policy? And what about the abuse that was exacerbated in past decades when this policy wasn't in place? Do you not think you owe IICSA some acknowledgement of the fact that we're dealing with a reform, that we're dealing with the organisation realising that this is a glaring error and fixing it, but just pretending that the error was never there? So that when abuse survivors come forward and say, this is what happened to me, I was made to confront my abuser, you're just dismissing those stories, and you're certainly not apologising for putting them through that unimaginable ordeal. I think that's going to be a challenge for IICSA to help the organisation realise that it's not just about what the policy says on paper now in 2020. It's about how did we arrive at this policy, what mistakes were made in the past, and what have you done to correct those mistakes. It's not simply about Tipp-Exing out or using correction fluid and pretending that these things never happened when there's actual damage being done historically that has ruined lives and made abuse so much worse.
We have evidence from a number of religious organisations, not just within the Jewish community, who see their community, with its emphasis upon family, upon strong personal morality, upon a need to guard children against what they would consider to be the sins of the secular community in the 21st century, in the strength of the need to guard children to preserve their innocence, and upon their religious observance as providing a greater degree of safety than the state. Examples of this we have seen and have occur in the Christian, Jehovah's Witnesses, Church of Latter-day Saints, Muslims, Sikh, Buddhist and Hindu communities.
So I was really pleased that Miss Scolding here alluded to the kind of insular nature of many of these groups, the fact that they perceive themselves as being morally superior to the world around them. They feel that the world outside their bubble, as it were, is evil and corrupt. And this itself represents a barrier to reporting abuse. If you think that your organisation's the very best and everything outside your organisation is corrupt, is defiled, why would you want to subject yourself to a judicial or moral framework that you consider to be inferior? So I was glad that Miss Scolding included this in her comments.
There are also concerns that when reports have been made, police and social services have acted in a heavy-handed or culturally inappropriate manner, without appropriately understanding and respecting the cultural and community norms present within these communities. This is not something, and the idea of not reporting out is not solely something which is related to the Orthodox Jewish community. For example, the Jehovah's Witnesses have or are alleged to have a similar rule, and there are very many other groups which identify that there should not be reporting out, even if sexual abuse had taken place.
I guess this was, and again, in fairness to Miss Scolding, she's cramming a lot of material in to a very finite amount of time, but she seems to be alluding to the fact that Jehovah's Witnesses are far from unique in considering that in certain instances, look, if we don't have to report, we're not going to report. That seems to be what she's referring to, or indeed that there is a reluctance to report. Again, I don't envy Miss Scolding having to kind of whistle through all of these different religions and observe all of the nuance for each different religion. Jehovah's Witnesses would probably take offense at her words, and they would say, of course, we involve the police whenever we feel that children are in danger, but unfortunately that's just not what we see when we look at the testimony of survivors, and indeed when we look at documented cases, including cases that have been through the courts. We see an aversion on the part of Jehovah's Witnesses when it comes to involving the authorities, whether that's because of fear of heavy-handedness on the part of the police, I'm not so sure. But Miss Scolding is right to note that there is an aversion among groups like Jehovah's Witnesses when it comes to involving the police.
Those individuals who make up the ex-Jehovah's Witness Advocates Group, represented by Miss Sarah Davies, say that those who report sexual abuse within the Jehovah's Witnesses, for example, have ties cut completely with other family members and are ostracised and ignored. Those who have reported abuse within the Jehovah's Witness faith tell us that they have been socially ostracised, which can mean children not speaking to parents, siblings not speaking to each other, fathers not speaking to daughters. That can have a profound effect on someone's life and can lead it to be very difficult for somebody to report sexual abuse for fear of that happening to them.
Again, I really don't envy Miss Scolding in summarising such complicated issues in just a few words. I guess that, look, I'm interested in keeping things as accurate and irrefutable as possible, and it's slightly unfortunate the way that the evidence given by the ex-Jehovah's Witness Advocates Group has been paraphrased, because CCJW, Jehovah's Witnesses, could turn around and say, well, that is simply not true. It cannot be said that if you report abuse, you will automatically be shunned. When you make absolute statements, you make yourself vulnerable to those sorts of counter-arguments. Jehovah's Witnesses can say, look, we have in our policy, here it says that someone who has been abused has the absolute right to report to the authorities. So how can you possibly say that we arrange for these people to be shunned if we're acknowledging their right to go to the authorities? And I'm going to come to that point later on. But you see the problem when emphatic, absolute statements are made. Watchtower is just going to come back and say, well, what you're saying flatly contradicts what we've said in our own policy. It would have been perhaps more prudent for wording to be used that was perhaps a bit more flexible. So, for example, it's not uncommon for survivors of abuse who speak out about their experiences and certainly litigate over their abuse to find themselves shunned by their believing friends and family either formally through disfellowshipping or informally because they are identified as bad association. I guess that would be my super accurate way of phrasing it, but again, I can't hold it against Miss Scolding. She's got her work cut out in briefly going through all of these various areas that the inquiry is looking at. It's just a shame, I guess, that witnesses watching this, if you just take that soundbite by itself, they're going to say, well, everything's stacked against us. This whole thing is rigged because what Miss Scolding has said there is contradicted by the policy itself. Again, by being just a bit more flexible in how this is worded, you give Jehovah's Witnesses less wiggle room to get out of this.
The next concept and the next barrier to reporting is that of forgiveness. The idea of forgiveness of the abuser is also something which has emerged from the evidence gathered. The concept of forgiveness of sins is very strong, and faith organisations have, on occasions, restored known abusers to a place of power if they demonstrate contrition and penance. This is often in the teeth of significant opposition from the survivor of the abuse, or without consulting them or taking their views into account. Moreover, victims are often pressurised to feel that they are only acting in an appropriately faithful way to their religion by forgiving their abusers. This can be impossible, and as we learnt in the Anglican investigation, is not necessarily a correct theological response in the Christian faith in any event. The Jehovah's Witnesses show us an example of this, as a repentant abuser can, on occasions, remain an active member of the congregation if they are found not guilty within the internal juridical process that the Christian congregation of Jehovah's Witnesses operate, or if they demonstrate something called reproof.
I think this was a really important point that Miss Scolding made. Again, probably a bit more accuracy with the language would have been preferable, but again, I don't expect someone who doesn't have intimate first-hand knowledge of these issues to understand the various parlance and the terminology, etc. But Miss Scolding raises a very important point, which I am keen to stress, which is that the whole concept of forgiveness raises, well, it not only raises a barrier to reporting, because if you think someone should be given a second chance, you're going to perhaps be minded towards limiting the extent to which they are punished. But also, the whole concept of forgiveness, if you think about it, serves to re-traumatize victims. Because if you are a victim of child sex abuse and your abuser somehow manages to convince elders that they are sorry enough, then your abuser will be merely reproved. Yes, they'll be placed under restrictions, but they'll still be a member of the congregation, able to attend meetings, able to mingle to some extent with the congregation. And if you're in that abuser's congregation, you will have to go through the ordeal, if you take your faith seriously enough, of going to your kingdom hall twice a week and sitting just a few feet away from an individual who has ruined your life. This is a practice that clearly will re-traumatize a victim of abuse, and it stems from this mistaken idea that child sex abuse is something that you can be sorry for. So those were just a few clips from the opening statement of Miss Scolding. Next up was my lawyer, Richard Scorer. We're going to focus now on the parts of his statement pertaining to Jehovah's Witnesses. And while you're watching, you may be interested to know that just to the left of Richard Scorer in the shot, the person sat at the back of the room, again, just to the left, is Shane Brady, who is the Watchtower lawyer. He's going to be speaking later, but it's just interesting to observe his body language as Richard Scorer is making some parts of his statement.
Thank you, Chair. Ms Harrison and I represent 7 organisations and individuals who work with and advocate for victims and survivors of abuse in many of the settings being examined in this hearing. Lloyd Evans is a campaigner and documentary maker who previously served as an elder in the Jehovah's Witnesses, but now works on behalf of those who are challenging some of the practices of that church. Over the past few decades, numerous inquiries have examined abuse in the Catholic and Anglican churches, and rightly so. There has been some public investigation, albeit nothing like enough, of abuse scandals in the Jehovah's Witnesses. But for various reasons, including political sensitivity, child sexual abuse in many minority religious settings has largely been ignored. The Australian Royal Commission touched on this issue briefly. But the reality is that for far too long, the authorities have marked this issue down as too sensitive or too difficult to grapple with properly. In some cases, the authorities have ducked the subject for fear of provoking social tensions or stoking discrimination. As a result, victims and survivors in minority religious communities have been silenced and their abusers in some cases given impunity. Silenced not only by their own communities and religious institutions, but also by the state's reluctance to tread in this territory. My clients have fought hard for many years against this wall of silence and have fought to open up a space where victims and survivors can be heard. So they welcome the opportunity provided by this hearing. At long last, the reality of what it means to be a victim of abuse in a Jewish, a Muslim, a Hindu, a Sikh, or a Jehovah's Witnesses setting might be glimpsed and maybe even addressed. So this is very welcome. However, by the same token, if this hearing is to have real and lasting value, it can only be the start of a much deeper process of scrutiny. You have only 2 weeks in which to examine a large number of institutions and settings. Inevitably, you can only scratch the surface. In this hearing, we have no disclosure of individual case files, and indeed no time to interrogate the detail of individual cases. We have none of the auditing of files by independent safeguarding experts which you commissioned for the Catholic and Anglican hearings. As you know, it was only in those hearings, it was only through forensic examination of individual cases that you uncovered the gap, the very big gap, between rhetoric and reality on child protection. In this hearing, you have many statements from religious organisations asserting that everything is basically fine. They have it all in hand, and many have seen no allegations anyway. Of course, you will do what you can to scrutinise these claims, but time is short. So this has to be the start of a much deeper process of scrutiny. There can be nothing worse for survivors than for this space to be opened up briefly, only for the door to be shut in their faces once again. We'll return to this in closing, but a key part of what you need to do following these hearings is to put in place mechanisms by which the scrutiny and oversight that you are starting here can be continued into the future. And without that, we say this exercise will ultimately have little value. Secondly, Chair, as you examine the evidence over the next 2 weeks, you might be tempted to draw on your experience of religion and abuse in the Catholic and Anglican hearings. Much of that experience will certainly be relevant, and there will be many parallels. But we also ask you to keep in mind some important differences between the Catholic and Anglican churches of today and many of the settings under scrutiny here. For one thing, 40 years of public scandal has forced the Catholic and Anglican churches to admit that they have a problem of child sex abuse. No current Catholic or Anglican leader would come before this inquiry now and seriously try to maintain that clerical sex abuse scandals had never happened. But in some, if not many, of the settings here, there is no such admission. Indeed, there is clearly a deep reluctance on the part of many religious leaders to admit that they even have a problem at all. Mr. Gillies, on behalf of the Jehovah's Witnesses, offers no indication of any problem whatsoever in a religious community that accounted for the 3rd highest number of religious victims coming forward to your Truth Project.
So you'll remember I mentioned this earlier about the Truth Project report. Richard Scorer there going for the kill and saying, how on earth can Paul Gillies seriously expect the inquiry to believe that there's no problem at all when, again, the religion accounted for the highest number of reports or participants reporting their abuse outside of the Catholic Church and the Church of England. So I love the fact that he drove home that point. It will be revisited in later statements before the inquiry, most notably by Sam Barker. But I love the overall argument that Richard is making here, that the inquiry has a huge task that it can't seriously expect to undertake in just 2 weeks of hearings. It would be an injustice to victims of abuse for, as Richard put it, for the inquiry to open the door briefly only to shut it in their faces once again. This is a really serious issue, and these hearings have to be just the start of a much longer process of investigation. I agree wholeheartedly with Richard on that, and I'm very proud of him for making that the opening part of his statement.
Some of the groups you are dealing with here believe fundamentally that child abuse is not really a problem for them. This denial and disbelief has significant consequences for children. It means that even where safeguarding policies are adopted, they may not protect children, but simply give the appearance of compliance so as to shield the organisation from criticism or scrutiny. It may mean that safeguarding policies can be ignored or not implemented effectively on the ground. And this is exactly what we saw in the recent Lancashire case concerning the Jehovah's Witnesses. The judge in that case looked at the safeguarding guidance published by the witness leadership in 2013 and 2018. The judge found that this published guidance was not followed by senior figures in the congregation. The judge concluded, and I quote, that the policy documents are ones that seem to be produced for public consumption, but not to be effective to protect children, something which the judge described as deeply troubling. Where organisations basically don't think that they have a problem, this has implications across the whole process of child protection. It means that these organisations are likely to respond to complaints of sexual abuse either with blanket denial or, more subtly, by discouraging and dissuading victims from reporting to the statutory authorities. It means that little thought will be given to the accessibility of safeguarding policies and the extent to which they are really known about and understood within congregations and communities. It means that victims who do choose to report are unlikely to get the help and support they need. Indeed, this is often deliberately withheld so that a victim who proceeds with a complaint is left to face the process isolated and alone. It means that victims also will be denied redress. Look at the experience of PRA5. To get reparation for serious abuse, she had to fight a legal case against the Watchtower all the way to the Court of Appeal. Even though the court found the Watchtower responsible for her abuse, she never received a full public apology from the Jehovah's Witnesses leadership. This treatment of a victim has its origins in the organisation refusing to accept that it has a problem in the first place.
I was so proud of Richard for mentioning PRA5. If you watched part 2 to this series, you'll have seen that I drew attention to the fact that PRA5 is due to, or was due to, give evidence on day 4 of the hearings. We're now hearing in Richard Scorer's opening statement that PRA5 litigated against Watchtower successfully but never received an apology. Well, there's only one person that could be, and that is the plaintiff in the A versus Watchtower case, the only case in the United Kingdom and arguably the first case ever in which a survivor of abuse successfully litigated against the organisation and the judgment was never successfully appealed or settled. So this was a massive case, and the argument that Richard is making here is, how can Watchtower be taken seriously when you have here, or we will be hearing from, a girl who suffered abuse, whose abuse was facilitated by Watchtower so that a court found Watchtower vicariously liable for abuse, and yet the leadership of Jehovah's Witnesses has nothing to say on the subject. What does that say about the organisation if they're not willing to even own up to a clear-cut case where a judgment has been reached, someone has been found to have suffered because of Watchtower's policies, and the organisation just folds its arms. So I am going to be fascinated to see what PRA 5 has to say again when these hearings resume, and I'm really proud of Richard for making PRA 5 a part of his opening statement, given the fact that PRA 5 is not a core participant and so doesn't have a lawyer who can give an opening statement at this part of the proceedings. It's nice that she was involved. I also really like the fact that Richard is really pressing the point of deniability. How can an organisation be taken seriously if all they do is deny, deny, deny? We're going to see Watchtower's attitude in this regard brought painfully into sharp relief by the statements that are made by other religions. I also like that Richard mentioned briefly about the accessibility of policy. It's all very well saying we have a policy and it was published in 2018, 2019, it's bang up to date, everything's there, you just need to read it. Okay, what form does this policy take? How many documents is it spread across? And are all of these documents all available to everyone? That's the question I think the inquiry needs to be asking. If you have certain policy documents that are available only on a need-to-know basis, so that what you actually have is a canon of policy where some parts of the policy can be read by families and abuse victims, but some can't, what does that tell you about the organisation, and how can that possibly be a responsible approach to take to child protection?
Chair, to return to my central point, in practice, in many of the settings you are examining in this hearing, religious power and authority can be all-encompassing. It permeates many aspects of daily life. In the Church of England, they talk about the Sunday Anglican who goes to church on Sunday but leads an entirely secularised existence for the rest of the week. But in many ultra-Orthodox Jewish or conservative Muslim or Jehovah's Witnesses settings, religious authority is ever present. In this environment, to question religious power, to challenge it, is to risk becoming a non-person. Sometimes this is done formally by the religious group, as with shunning and disfellowshipping in the Jehovah's Witnesses. Sometimes, as in South Asian communities, it operates through the concepts of honour and shame, whereby women who challenge patriarchal religious authority risk ostracisation and violence. But by challenging, by pointing out the problem, you become the problem. A third and related factor is that in the settings under examination in this hearing, communities can be relatively closed and isolated from the secular world. The Catholic and Anglican churches are rightly criticised for their failings on sexual abuse. But those churches, at least today, are much more integrated into wider society than many of the organisations you are examining now. And this has significant implications for child protection. To take just one example, in the Catholic Church of today, a diocesan safeguarding commission will typically include professionals with experience in secular organisations like the police, social work, teaching and law. A commission might include non-Catholics. By contrast, when you think about the Jehovah's Witnesses, for example, the idea of a circuit or region of that church having a safeguarding commission staffed by secular professionals is totally inconceivable. It wouldn't happen because the Jehovah's Witnesses leadership regards the external world, the secular world, as corrupt and evil and not as a source of useful guidance and expertise. The Jehovah's Witnesses are, of course, entitled to hold the beliefs that they do, but it has to be recognised that this belief system has important implications for child protection. It means that in many of the settings you are examining, secular expertise and child protection norms will not readily be welcomed voluntarily. They will have to be brought in from outside and compliance monitored from outside.
Another really important point there that Richard's making, really highlighting the insular nature of Jehovah's Witnesses and the fact that their attitude towards society in general, or Satan's system of things, acts as another barrier to the organisation dealing with child protection in a responsible manner. I know that Richard has become something of an expert in the way that child abuse has been dealt with by the Catholic Church. I think he's even written a book on the subject, in fact, so which I've actually ordered from Amazon. I haven't read it yet. But he really knows what he's talking about when he's referring to the steps that have been put in place by mainstream religions that are less averse to society in general and less paranoid, you could say, about involvement with outsiders, so that in the Catholic Church, a diocese will have a commission set up that will include people who are not Catholics. They will include people based on their professional skills in dealing with child safeguarding, not just whether they're good Catholics or not. It's inconceivable, as Richard Scorer says, for Jehovah's Witnesses to allow outsiders to come in and involve themselves on a case-by-case basis with stories of abuse that are brought to the attention of the organisation. It's just not going to happen. Jehovah's Witnesses will be resistant to that suggestion to the very last, because they would see that as Satan's system of things encroaching on a judicial process that is part of Jehovah's means of justice and discipline.
Where particular modes of thought and behaviour are deeply ingrained, it takes a correspondingly forceful push to dislodge them. Whether that has really happened is a good measure of how serious an organisation is about change. Similarly, you will have heard about the two-witness rule, which operates in the Jehovah's Witnesses and in some fundamentalist Christian churches. The rule that two witnesses are required for a finding of abuse. The Jehovah's Witnesses leadership denies that this rule inhibits the reporting of allegations to the statutory authorities. We dispute that, and we urge you to probe this point very carefully. But in any event, as their counsel, Mr. Brady, alluded to in his remarks in the first preliminary hearing, it clearly does influence how the Jehovah's Witnesses deal with the question of whether those accused of abuse should have any continuing role in their congregations. So for internal purposes, the two-witness rule still operates as the overarching principle. We urge you to explore what that means in practice. We urge you to be very cautious about accepting claims of change, and we urge you to keep in mind that if certain ideas which are deeply ingrained in religious settings inhibit reporting to the authorities, then the only way to overcome this is likely to be through mandatory reporting, and of course by taking away individual discretion over whether to report. Mandatory reporting protects individuals who do seek to report.
So I was glad to see Richard there speaking of the need for mandatory reporting. Again, Richard has a long track record in advocating for abuse survivors and dealing with child sex abuse at an institutional level. So he has been advocating for mandatory reporting for some time now, and clearly he's looking at Jehovah's Witnesses and seeing a clear example of why mandatory reporting is needed. But I also like that he is referring to the culture, to the religious beliefs and ideas and practices that underpin the way things are handled. Again, it's one thing for Watchtower to point to their policy and say, oh, we've written this down, therefore this is what's happening. It's another thing entirely to spend years as a Jehovah's Witness and understand how things are done and understand how people think. And that has a very strong bearing on how things like child sex abuse are handled. Richard there as well referring to the two-witness rule and the fact that in the preliminary hearing, Shane Brady, or one of the preliminary hearings, Shane Brady tried to argue that the two-witness rule has no bearing on the extent to which abuse is reported to the authorities. Now, he can say that, but if the organisation can be demonstrated as withholding reporting, even in cases where someone is a threat to children, then quite clearly the two-witness rule is playing some role in influencing the thinking of elders and service department personnel when it comes to making sure that abuse gets covered up. Richard also makes the point, a very good point, that even if you want to argue that the two-witness rule has no bearing on whether abuse is reported to the secular authorities, it still has a bearing on whether an abuser or a pedophile is either disfellowshipped or reproved. So the two-witness rule dictates whether a judicial committee can be formed to begin with, and therefore dictates whether a pedophile is free to mingle, or to what extent a pedophile is free to mingle within the congregation, and that has massive child protection ramifications. So even if you want to give Watchtower the benefit of the doubt when they say, oh, the two-witness rule wouldn't stop us from reporting abuse, they cannot argue that it doesn't have at least some role in allowing perpetrators opportunities to access more victims.
Finally, Chair, I want to say something about the central issue for this hearing, which is whether or not religious bodies are going to carry on self-regulating, whether, in terminology we've heard before, they are allowed to continue marking their own homework. We say that the evidence from Catholic and Anglican hearings is very clear. Self-regulation doesn't work. In this hearing, you won't have the opportunity to examine individual cases forensically, so we understand that you may be hesitant about drawing definitive conclusions about handling of cases in any particular setting. And of course, you will also, and rightly, hear examples of good practice. But as you hear the evidence, we urge you to stand back and take a common sense view. Many of the groups submitting statements for this hearing say they have few or no allegations. That in itself ought to ring major alarm bells. So should the assertion that religious settings are less likely to experience abuse. But most of all, in considering the issue of regulation, we urge you to heed the voices of victims and survivors and their advocates. Chair, to finish, we also urge you to treat with scepticism arguments for self-regulation based on religious freedom. Some of our clients are religious, some are not. All of them care about religious freedom and believe that it matters in a free society. None of our clients want the state to dictate what people can believe. But as you know, religious freedom is not an absolute right. It can be legitimately abridged to protect the rights and freedoms of others. And there are few rights and freedoms more important than the right of children to be free of sexual abuse. Where children are at risk, the state has a legitimate right to require action to protect them. Most institutions in wider society now expect to be held accountable, and particularly in regard to safeguarding. Registration of those undertaking relevant activities and external oversight of safeguarding is now the norm in wider society. Nobody seriously thinks that it imperils our freedom. On the contrary, it exists precisely in order to protect the rights and freedoms of children. Religion cannot be treated differently to any other part of society, and indeed there are many people within religious settings who care about children and don't want religion to be given a free pass on this either. So we say, Chair, that pleas for religious freedom in this context are really pleas for religious exceptionalism, self-interest masquerading as principle. Those pleas should be rejected. Chair, those are our opening submissions.
Thank you, Mr. Scorer.
Another really strong point there from Richard. In fact, 2 points. First of all, he brilliantly words it. He indicates that this is wording that's been used before, but he says that religion shouldn't be allowed to mark their own homework. So a religion shouldn't be able to just say, oh, everything's okay, trust us, we have this policy, just believe us in saying that everything's under control and everything's absolutely perfect. It shouldn't be the case that religions get to, as Richard puts it, self-regulate and decide for themselves whether they have a clean bill of health. He also brings in this very important point about religious freedom, and I'm especially glad that he raises this in light of the way that Watchtower responded to the Utrecht University report, which was very damning, you could say, in highlighting how inadequate Watchtower policies have proved to be in the Netherlands, and the way Watchtower responded to that report, specifically Shane Brady, who jetted out to the Netherlands to try and stop the report from being published to begin with. The way Watchtower responded to the report was to say, oh, we're being discriminated against. This is hate speech. Our rights, our religious rights are being violated here. So Richard is trying to prepare, I think, the inquiry for that sort of rhetoric. And he's saying, look, a religion that says it's our religious right to do this is asking for exceptions to be made. And although everyone has a right to worship as they see fit, everyone has a right to hold beliefs that are even obnoxious or offensive to most people, what religious freedoms do not guarantee you is the right to export abuse and misery on other people, and particularly to facilitate or in some way turn a blind eye to the sexual abuse of children. But that was the opening statement from my lawyer, Richard Scorer. We're now going to go to the lawyer for the XJW Advocates Group, Sam Barker. Just bear in mind that it's going to take the camera a while to switch to him, so you're going to hear his voice before you see him. But up next, as I said, is Sam Barker.
I appear on behalf of the ex-Jehovah's Witness advocates opposing crimes against children, who I'll refer to as the group in this opening statement. Chair, yourself, the panel and all of us are here today because there is a justifiable concern that children within religious organisations are not being properly protected from the risk of child sexual abuse. This risk is not hypothetical, it is not fanciful, it is real. The Truth Project's report confirms this risk still exists in religious settings in the UK, and it is the job of this inquiry to take steps to help correct this. So how can you do this? It sounds like a daunting task, and indeed it is. And this inquiry is well placed over the next two weeks to take steps in the right direction. But the group urges you to not be misdirected by claims from the Jehovah's Witness organisation that it does not have an ongoing issue with child sexual abuse. The Truth Project's report in of itself shows that this is not the case. You need to look past what is simply written down. You need to examine how policies work in practice and how the effectiveness of those policies is affected by what is unofficial. You cannot just accept, because an organisation abhors child abuse, that it is taking every possible step available to it to help protect children from that risk. The inquiry has appointed the group as court participants to these hearings because they can provide that insight into what is unofficial. And it can help the inquiry look past the well-constructed exterior and examine what actually presents a risk to children within the Jehovah's Witness organisation today. And why is the group uniquely placed to assist the inquiry in this way? Because members of the group have been failed by the Jehovah's Witness organisation. Some have been sexually abused themselves as children when members, and some have children who have been sexually abused. Some have been subjected to the two-witness rule, some have been shunned, and some have family members who have been broken by the practice of shunning. And all of the members of the group are able to provide this inquiry with a true insight into shortcomings which continue to place children at risk. The group has done this through its 2 witness statements and the 3 personal statements exhibited to that witness statement. We must not lose sight of the fact that this inquiry is for survivors of childhood sexual abuse, to be heard and to take steps to ensure that this does not occur again. To this end, I thank PRA39, PRA40, PRH14 and Sarah Davies for their invaluable contributions. These witnesses have disclosed their own sexual abuse to help you understand the cultural and systemic issues within the Jehovah's Witness organisation which failed them.
So again, the XJW Advocates Group is, you could say, a large group made up of various different individuals with first-hand knowledge of the way the organisation is dealing with abuse. Samuel Barker is their legal representative, and he's giving here a very forceful, very persuasive opening statement, really telling the inquiry, again, not to take Watchtower's words at face value. He's also pointing out that there's denialism in the Jehovah's Witness organisation. If you think about it, if Watchtower wanted to be strategic and undermine the credibility of both Richard Scorer and Samuel Barker, what they would do is get up on the stand knowing that not every Jehovah's Witness is going to be watching these hearings, quite frankly, and say, oh yes, we apologise, that would completely throw into doubt, again, the credibility of Sam Barker and Richard Scorer, who are both telling the inquiry, this is an organisation that is not going to apologise. And yet, as we're going to see later, when Shane Brady gets up to give his statement, rather than making Richard Scorer and Sam Barker look stupid by being humble and saying, yes, we have a problem here, we're deeply sorry, we realise how people's lives have been ruined by the way we've treated their experiences and so on and so forth, rather than saying anything like that, what Shane Brady will do is completely live up to and embody the description of the Jehovah's Witness religion that Richard Scorer and Samuel Barker have supplied here. Again, a religion that accounted for such a large number of participants in the Truth Project, which Sam Barker here reiterates.
Today, we must ask ourselves why we're here. The reason is because something has gone gravely wrong. Children have been sexually abused in religious organisations, and this abuse was preventable. If proper safeguarding was in place, we would not be here today. If every allegation of child sexual abuse was taken to the police, we might be a little bit more assured. But that is not the case, and we must not shy away from that fact. The inquiry will investigate, as part of these hearings, the child safeguarding policies in relation to a number of religious organisations in order to determine whether those are adequate to protect children going forward. In order to do so, the inquiry must not lose sight of the fact the true inhibitors to proper safeguarding are not necessarily apparent on the face of policy documents, but they permeate an organisation through culture. In the group's view, there are 4 fundamental cultural issues within the Jehovah's Witness organisation which affect child protection, and those are: 1. Members are dissuaded from even reporting the fact that they were sexually abused for fear of being disbelieved, shunned, blamed, or scrutinised by outdated biblical standards as part of the scriptural investigation, such as the 2-witness rule, which you have already heard some of about today. 2. Elders are instructed that their primary concern is in maintaining the sanctity of God's name. And this, together with a long-standing preference to protect the reputation of the congregation, the faith, and Jehovah, deprioritises the proper handling of an allegation of child sexual abuse. The Lancashire case is a recent and troubling example of this. 3. An elder's advice to a member to leave matters in Jehovah's hands, whether communicated directly or indirectly, has a profound and lasting effect on that member, such that it will very often result in them not taking that report to the police and leaving matters to be dealt with scripturally and internally. And 4, the Jehovah's Witness organisation considers itself separate from secular laws and the secular world. Why else would it frequently refer to secular laws as Caesar's laws and instruct elders to comply with secular laws when they do not conflict with God's laws? The Bible is not a handbook for safeguarding. Proper safeguarding training is not a series of biblical quotes. And an organisation which refuses to engage with secular authorities to better their own practices is not taking this risk seriously enough. The inquiry must be open to these cultural issues which prevent a survivor reporting their abuse to the police, because these do exist, and it does affect child protection in an ongoing and ascertainable way. The abuser may offend again.
So Sam here is making the argument quite forcefully that there are a number of cultural elements to the Jehovah's Witness religion that create a perfect storm, if you will. I would agree with most of what he said there, the 4 points that he raised. I would only add the caveat on point 1 that, again, if you're going to say that Jehovah's Witnesses are dissuaded from reporting, you are basically setting Watchtower up to say, yes, but look at what we've said here in our policy, where we say that an abuse victim or one of their family members has the absolute right to report what happened. I want to give Watchtower as little wiggle room as possible by being as precise as possible in how these things are worded. So I would have preferred it to be more a case of saying that certain beliefs in the Jehovah's Witness religion have the effect of dissuading victims from approaching the authorities, such as the notion that you shouldn't take your brother to court, and the notion that you shouldn't insist on your personal rights. Particularly that point about personal rights is useful, because if Watchtower then comes and says, oh, we always make it clear that it's their right to report, and if you can present a quote, which you can, from the literature saying, of course, we wouldn't always want to insist on our rights, and just because you can do something doesn't mean you should do that thing, well, then you're pushing Watchtower into a corner, and you're proving that it's the culture itself, rather than necessarily what's written down in the policy, that is, again, serving to dissuade, rather than witnesses being outright told you shouldn't report abuse, which is probably what mostly happened in previous decades. But Watchtower would argue it's not what happened decades ago, it's what's happening now. That's what the inquiry is set up to establish, what the current practices are. So Watchtower will want to, as much as possible, point to their policies. And I'm very, very anxious to highlight the way that they use language in a very clever way to mask over things that only come to light when you have a deep knowledge of all the various beliefs and the nuances to Jehovah's Witness culture.
Finally, the inquiry must look past mere assertions and assess how written policies, procedures and communications affect child protection in practice. You must critically examine the CCJW's position that safeguarding and the scriptural investigation are separate and distinct. This is simply not the case. In the absence of a mandatory report to authorities to properly deal with an allegation of child sexual abuse, the complaint is subject to the two-witness rule. If the allegation is not established, which it rarely will be if it's subject to the two-witness rule, an individual who might pose a risk to children is left in the congregation and in the community without trained officers having considered the merit of that allegation or the ongoing risk that person poses. To say these practices are not related in of itself betrays a serious misunderstanding of proper child protection. It is not done in silos, it must be all-encompassing. You need to look into the deflection of responsibility for safeguarding to parents and refer to your own source material which confirms this is not good practice. If the CCJW's position on these issues is simply accepted and not critically examined, it will leave a void where risks to children continue to grow. If the inquiry looks past what is simply written down on paper and draws conclusions from practical examples of safeguarding failings within the Jehovah's Witness organisation and makes recommendations in order to correct these failings, you have a real opportunity to make a difference and to better protect children in the Jehovah's Witness organisation going forward. The group would like to thank the inquiry for the opportunity to participate in these hearings and, of course, offer any kind of assistance necessary going forward. Thank you.
Thank you, Mr. Barker.
Very strong concluding comments there by Sam Barker, again addressing this argument that Watchtower was making in the preliminary hearings, that look, yes, we have the two-witness rule, but that doesn't have any bearing on whether we will report abuse or not. Sam Barker making it very clear that it absolutely does serve as the overarching principle when Jehovah's Witnesses are looking at cases of abuse and deciding what action to take. I also like Sam Barker bringing to the fore this idea that protecting children from abuse is somehow the responsibility of the parents. That, again, is rhetoric that you will find strewn throughout Jehovah's Witness literature on child abuse, including the May 2019 Watchtower. And this is simply not a responsible position to take if you are an institution entrusted with the well-being of children. Now, we've just been hearing from the core participants, you could say, against Watchtower, or the representatives of the core participants who are producing evidence that is critical of Watchtower policy. We're now going to be hearing from Shane Brady, who is the lawyer representing CCJW, the Christian Congregation of Jehovah's Witnesses. But before I show you Shane Brady's statement, let me show you some clips from statements that were made by representatives of two other religions. The first you're going to hear from is a representative from the United Reformed Church, and the next you're going to hear from is a representative from the Methodist Church. And just take a note of the approach they take when coming before the inquiry.
As the United Reformed Church Safeguarding Lead and Secretary of its Safeguarding Advisory Group, I want to thank the Chair and the panel for the time and space to hear from a small, non-conformist Christian denomination in the UK. URC has 50,000 members, so it's a very small denomination. I would like to start my statement by apologizing to survivors of abuse within our church, to their families, supporters, and communities. Between October 2015 to June 2017, the United Reformed Church undertook a past case review, a courageous journey for many, especially for survivors, that shed light on uncomfortable truths of the past of our church, as well as allegations and cases of harm and abuse, including child sexual abuse. The United Reformed Church acknowledged the past failures of the church with a public apology, and the courage of survivors, some of whom disclose exceptionally difficult, life-changing experiences of trauma and abuse.
The Methodist Church is the fourth largest Christian denomination in Britain. It has approximately 173,000 members, and it's estimated that about 27,000 children and young people attend Methodist Church services and activities each week. The Church recognizes that, like so many other religious institutions, it has made mistakes in the area of safeguarding. It has placed the reputation of the Church above the interests of the victims or those hurt by abusive behavior. It has mishandled complaints. It has acted with insensitivity, and therefore it has failed to live up to its fundamental principles. For all of its wrongs and its lack of understanding, the Church unreservedly apologizes.
So you have there a representative of the United Reformed Church and a representative of the Methodist Church, and both are falling over themselves to apologize, to seize the opportunity to recognize what they have put victims through, or not them personally, but what their institutions and organizations have done to make things so much worse for victims. They've looked at the inquiry and what it's setting out to accomplish, and they've realized that any sort of denialism or defiance or arrogance is entirely inappropriate in this context. Either your organization is perfect, or there's a problem, and a problem that requires an urgent apology. And clearly, if your argument is, we don't have a problem, therefore our organization is perfect, you are operating in cloud cuckoo land. And I'm sure I'm not spoiling anyone's expectations by saying that Shane Brady is going to come before the inquiry and completely ignore the script, completely ignore this very obvious approach that's being taken by other religions, and effectively say, we don't have a problem. Nowhere in his statement is he going to identify any area where there's a problem, and he certainly isn't going to apologize. In my view, it's like turning up at a funeral in your pajamas. Everyone else understands that this is an occasion where there is a certain decorum, and you just sweep in and completely ignore the script and completely disrespect the whole nature of what's happening. That's essentially what Shane Brady is about to do in his statement.
Mr. Brady.
Chair and members of the panel, thank you for permitting us the opportunity to participate in this important investigation. We, by that I mean the Christian Congregation of Jehovah's Witnesses, would like to share with the inquiry our experience in doing our best to deal with this challenging issue. And we hope that our contribution will be of assistance to the inquiry as it makes recommendations for the better protection of children. In my brief remarks, I would like to summarize the policy of Jehovah's Witnesses as it relates to the broader issues that this investigation is examining, and also to briefly respond to some of the criticisms that you've already heard. Briefly, I would like to discuss the history as it relates to this issue. For over 35 years, the religious organization of Jehovah's Witnesses have alerted individual adherents and the public at large on the need to protect children from sexual abuse and to assist victims of this terrible crime. We've done so by publishing dozens of articles and videos in hundreds of languages and in tens of millions of copies. And some experts have noted that the literature that we produced in the beginning, the 1980s and the 1990s, were ahead of its time. Those early publications were the beginnings of our current child safeguarding policy. And we believe that they demonstrate our firm commitment to dealing with this issue. Our child protection policy has not stood still since then.
Well, that's because it's needed to reform to at least some degree to try to mitigate against the avalanche of lawsuits that have come Watchtower's way in recent years. It certainly has moved to some extent. We have seen some reforms. Nobody is arguing that there has been no change since the 1980s and 1990s. It's just that in the fundamental ways in which it needs to reform, Watchtower is very resistant to reform, such as, for example, the two-witness rule. But just interesting that, well, first of all, you noticed Shane Brady saying that he is going to respond briefly to some criticisms, and we're going to see what he means by what his idea of responding to criticisms is. And secondly, he trots out this trope of, oh, we're a fantastic organisation because over 35 years we have been producing all of this material on the subject of child safeguarding. Simply the volume, apparently, and the number of languages in which this material has been published is a redeeming factor. It's an area in which the inquiry should just say, oh, well, in that case, as long as you've been publishing stuff on child sex abuse, what were we even thinking inviting you here? It's just a non-argument. And frankly, what is the nature of this material? Does this material anywhere clearly and unequivocally tell a victim of abuse or their parents to report the abuse to the police? If in 35 years there isn't a single example of Jehovah's Witness abuse victims or their parents being told to report child sex abuse to the authorities immediately, then you cannot point to 35 years worth of material as being an exonerating factor. If anything, it's incriminating that in all of those years you haven't once been able. I mean, a really good example, if you're a Jehovah's Witness watching this, go and look in book 1 of the Young People Ask book. There's a section on how to deal with the aftermath of sexual abuse. Try to find where it says go to the authorities, go to the police. And that's the Young People Ask book. That's the book that young people are supposed to refer to when they have problems. And it doesn't say go to the police. And another thing Shane Brady tries to argue is that material that was printed in the 1980s and 1990s was ahead of its time. Well, let me give you one example of an Awake article that was printed in 1981 dealing with child sex abuse, albeit in the guise of incest. So obviously incest and child sex abuse are not one and the same, but nevertheless, child sex abuse is explored in the context of incest in this article. It's the February 8th, 1981 issue of The Awake. Let me read part to you. Some adults who turn to incest are psychotic. Most are not, however. They may be apparently good family men, business or community leaders, even good churchgoers. Why do such ordinary people commit incest? Loss of control due to alcohol has been involved. Family problems can contribute. Hank Giaretto says usually it's a man losing his job or going through a low ebb period in his life. He and his wife become alienated. The father reaches out to his daughter looking for closeness. She is open to him, loves him, thinks he's great. The first overtures are not sexual. It's the sexual climate of our society which helps create the problem. We teach our girls to be Lolitas and sexual provocateurs from the time they're two. This apparently is ahead of its time in dealing with child sex abuse in 1981. It's effectively saying anyone can be a pedophile under the right circumstances. All it takes is losing someone's job or alcoholism or some kind of family problem, and hey presto, someone starts abusing their children. I'm sorry, that's what the logic is here. And no one's going to tell me that this is appropriate, sensible, well-reasoned, well-founded advice to be dispensing to families. The same article says, sometimes as children start to become young men or women, their parents, afraid of falling into incestuous relationships, become cold and distant. This is actually quite disturbing when you consider that the writer is not providing any source for this statement, which gives you the impression that maybe the writer is writing from personal experience. I mean, on what is he basing this? He's saying that if parents grow distant from their teenage children, it might be because they're afraid of entering into a sexual relationship with them. This is the advice. This is the advice that was apparently ahead of its time that Jehovah's Witness parents were receiving in 1981. Later on it says, some feel that prison is not always the answer for the molester. Is this advice that Watchtower stands behind? Is this advice that Shane Brady would support before the inquiry? Would he read that out and say, yes, we absolutely stand behind this comment that prison is not always the answer for the molester? And further on it says, explaining what he thinks is very important in such treatment, Hank Giaretto says, the father must face the daughter and accept full responsibility for whatever happened. This may be difficult for the father to do, but it is a way he can try to undo some of the harm that has been done to the child. It could be just me, viewers, but this seems to be indicating the need for confrontation between an abuse victim and their abuser, in the case of the father being the abuser. So this is material that, according to Shane Brady, was ahead of its time and giving parents the information they needed to protect their children.
Our core child protection documents were revised in 2018 and 2019, and we continue to review that policy. And may I assure you that we are open to suggestions on ways to improve and clarify that policy.
This is very clever wording. We are open to suggestions. We're open to listening to whatever you have to tell us. By all means, make your recommendations. What he's not saying is we are under no obligation whatsoever to implement your recommendations. Don't think that just because you are the independent inquiry for child sexual abuse that we are in any way obligated as a religion to implement those recommendations. So again, it's very clever wording. It's giving the impression that the organization is open for business, when in truth, this is an organization that considers itself Jehovah's organization appearing before a public inquiry in Satan's wicked system of things. If you're on the panel of the inquiry, you could be tempted to think, oh, well, this is a very reasonable position that he's taking. But you need to read between the lines, and it's not what he's saying, it's what he's not saying.
Now, of course, for a child protection policy to be effective, it needs to be tailored to what an organization does. What do Jehovah's Witnesses do as a religious organization? Well, as a religion, we are family-focused. We do not sponsor any activity that separates children from parents.
I want you to take note of that. We do not sponsor any activity that separates children from their parents. This is actually a lie. I'm willing to say that on record because I can prove that that's not the case. And he's going to repeat this lie later on in his opening statement. The truth is that children of Jehovah's Witnesses are separated from their parents in a number of different situations that Shane Brady is very well aware of. They're separated from their parents routinely when it comes to meetings for field service. So an elder or ministerial servant who is taking a meeting for field service could, for example, assign a minor to work with a non-relative, and no one would bat an eyelid. The parents would be perfectly fine with it because he is an elder or he is a ministerial servant and he has the authority to do that. So if your child is heading off down the street with a non-family member who's been assigned to work with them by an elder, you are being separated from your child, especially if that non-family member then says, actually, I've got some return visits. Do you want to jump in the car? You're not telling me that that doesn't happen. It's a clear example of a church-sponsored activity, the field ministry, where elders and servants are making assignments. This is actually, incidentally, a huge sticking point in the Candace Conti lawsuit, because those of you who followed that particular case will know that the case largely got appealed and settled, but one point that Watchtower could not avoid in that case was the fact that elders paired Candace Conti with Jonathan Kendrick in the preaching work. It was an activity in which a child was separated from her parents. And in fact, there's even a video produced by JW Broadcasting which shows a meeting for field service in which an elder or ministerial servant appears to be assigning individuals, including at least one child. This elder is assigning them to work with presumably non-family members.
Anyone made plans to work together?
Though I do meet with the group sometimes on Saturday.
Sister Martin, can you work with Rachel today? Thanks, everyone. Anyone made plans to work together?
So it's just an objective fact that meetings for field service happen, that these meetings are conducted by elders and servants, that these meetings are church-sponsored activities, and that at these meetings, children of Jehovah's Witnesses are routinely separated from their parents to go off and do either door-to-door preaching or, in some cases, return visits. And when they are in the hands of someone else, when they're in the care of someone else, anything can happen. Ironically, we've already heard about PRA5. PRA5's story involved a ministerial servant assigning himself to do preaching work and using that as an opportunity to exploit a child and abuse a child. So how Shane Brady Knowing all of this, with access to PRA 5's witness statement, with access to whatever arguments he's received about meetings for field service, how he can stand in front of the inquiry and tell this bald-faced lie that parents are never separated from their children is beyond me. By the way, it's not just meetings for field service. Elders also have the authority to assign someone to conduct a Bible study with a child of a believing parent, and this is even mentioned in the Shepherd book, which Mr. Brady will allude to. There's also the practice of going through baptism questions with someone who might be a minor. Now there it's a little bit more hazy, because there's wording in the publications to suggest that ideally parents would be involved, but there's also wording that suggests that if parents can't be involved, two elders or an elder and a ministerial servant will go ahead and take a baptismal candidate through the questions, even if they're a minor. So whichever way you want to cut it, there are clear documented examples of practices within the Jehovah's Witness religion in which children are separated from their parents in a church-sponsored activity. Shane Brady completely denying this to the point of lying about it in front of the inquiry.
Each congregation of Jehovah's Witnesses holds 2 weekly religious services, one on a weeknight and one on the weekend. And each service lasts an hour and 45 minutes. Now, as part of that family focus, families attend the services together, with children and parents sitting together. One point I'd like to stress is that Jehovah's Witnesses believe that the Bible teaches that parents are responsible to provide religious training and education for their children. That is a core religious belief. And it's for that reason that congregations of Jehovah's Witnesses do not sponsor daycares, Sunday schools, youth groups, clubs, camps, overnight trips, or the like. And so we submit that our safeguarding policy, our protection policy, needs to be considered in the light of what we do, as indeed with other religions.
Again, being so clever here, first of all, re-emphasizing and doubling down on the idea that it's all the parents' fault, it's all the parents' responsibility, but also trying to insist again on this idea that Jehovah's Witnesses don't have anything to do with separating children from their parents by listing a number of examples in which other religions might separate children from their parents, whether it's for Sunday school or daycare or whatever. He basically lists all of the examples in other religions that don't apply to Jehovah's Witnesses, while forgetting about meetings for field service, baptism questions, arrangements for Bible studies for children of believing parents. He ignores all of the relevant things to Jehovah's Witnesses, effectively trying to trick, you could say, the inquiry into thinking that much of the concerns that might apply to other religions don't apply to Jehovah's Witnesses.
Now, as far as the policy, we have read with concern the Lancashire judgment that was referred to earlier in the submissions by some of the other participants. On reading the judgment, it seems clear that the judge did not have before her all of the policy documents of Jehovah's Witnesses. And I don't propose to address that judgment in my submissions, but I do encourage you, Chair and panel, to look at the first supplementary statement of Mr. Gillies, which addresses that judgment in detail.
So you may remember that earlier in his statement, Shane Brady promised that he would briefly address some of the criticisms from the earlier opening statements of Richard Scorer and Sam Barker. And if this is an example of him answering a criticism, I have to say I am not impressed, because in the Lancashire case, you have a very damning judgment by Mrs. Justice Leven, who has a lot of experience in dealing with child safeguarding. Richard Scorer went as far as to quote some of that wording and how Justice Leven was very disturbed by the fact that some of the policy appeared to be written just to satiate outsiders rather than have an actual impact on keeping children safe. And Shane Brady's response appears to be, oh, well, did the judge have all of our policy in front of her? And anyway, just refer to what Paul Gillies has had to say on that particular judgment. Paul Gillies will probably know better than Justice Leven. That seems to be his argument. Either you're going to present a compelling counter-argument to a judge who has considerable experience in adjudicating matters pertaining to child safeguarding, or quite frankly, it would be better not saying anything at all. It certainly isn't a satisfactory counter-argument to simply say, oh yes, well, Paul Gillies has got an opinion on that, so just see what he has to say.
Our current child protection policy is implemented in 4 core documents. The first is the policy itself. The current version is dated April 2018, and it's readily available on our official website, jw.org, in dozens of languages. The second is the May 2019 issue of the Watchtower, which is the principal religious journal of Jehovah's Witnesses. And that magazine contained 3 articles that discussed the policy in detail. It was discussed, those articles were discussed in 3 religious services by all congregations of Jehovah's Witnesses in England and Wales in July 2019. And I think it's important to underscore that article, the fact that that article was produced, emphasizes itself that Jehovah's Witnesses do not feel they're immune from the problem of child sexual abuse. The fact that it has happened is one of the reasons why the article was produced and was studied by all congregations to discuss this frank subject. The third core document that Jehovah's Witnesses have produced as part of their protection policy is the October 2019 edition of the Elders Handbook, Shepherd the Flock of God. And that handbook includes Chapter 14, which gives specific direction to congregation elders how they should respond to an allegation of child sexual abuse. Finally, referring to the submissions of counsel for the inquiry in the opening, we would like to underscore that as a religious organization, our response to allegations of child sexual abuse is coordinated on a national level by the Britain branch office of Jehovah's Witnesses, and in particular by experienced elders who work in the service department of the branch office. So the fourth core document that is part of our policy is the January 2019 edition of the Guidelines for Branch Office Service Desks. And those guidelines provide guidance for experienced elders in the service department to assist congregation elders in responding to allegations of child abuse. And in response to some of the criticism you've heard a moment ago, those guidelines specifically address these subjects: reporting allegations of child abuse to the statutory authorities, ensuring victims are provided with pastoral support, and imposing strict restrictions on offenders if they're not expelled or if someone with that history wants to become a member of the congregation.
So I'll come back to what Shane Brady was just saying then about policy documents, but I just want to draw your attention to another attempt apparently on his part to answer some of the criticisms that we heard in the opening statements by Richard Scorer and Sam Barker. Shane Brady saying, well, we talk about reporting in our policy. We talk about it. So what's the problem? Just mentioning reporting to the statutory authorities in the policy does not excuse the fact that instances of abuse aren't being reported to the statutory authorities if the branch so decides. That's the whole point. You talk about the branch at a national level having overarching control with the use of experienced elders, but you ignore the fact that it is for the authorities to decide whether children are in danger and whether someone needs to be criminally prosecuted for child abuse. What Shane Brady is effectively doing is justifying the concerns voiced by Richard Scorer earlier about self-regulation. Shane Brady is here effectively saying we get to mark our own homework. Now, going back to what I'm calling the canon of child abuse policy, again, it's just confirming, if you think about it, what was said in earlier submissions. He's saying, yes, we have a policy that is stretched out across multiple documents, some of which aren't accessible to all victims of abuse. So he's listing the scriptural position document that can be downloaded from jw.org, and he's mentioning the May 2019 Watchtower, concerning which I have done a video explaining all of the various problems with that Watchtower article. He's then referring to the 2019 edition of the Shepherd book, which obviously is just for elders. And he's even referring to a document called the S66, which is guidelines for branch personnel. What's the full title? Child Protection Guidelines for Branch Office Service Desks. Now, interestingly, this document can be downloaded from avoidjw.org. If you go to avoidjw.org/manuals, and you scroll down to the heading Branch and Circuit Overseer Handbooks, Textbooks, under item 10 you have Child Protection Guidelines for Branch Office Service Desks. So we're dealing with a leaked document that Watchtower doesn't want ordinary witnesses to see. This is not an official Watchtower website. They do not give victims of abuse or even just ordinary congregation members access to this part of their policy, just like with the Shepherd book. But if you go ahead and download it, you get, I think, the 2016 version of the document. And I would just encourage anyone to scroll down to paragraphs 25 and 26, where it deals with whether to remove branch-imposed restrictions. And I think it's worth reading those paragraphs in light of what we're going to hear Shane Brady argue about how wonderful restrictions are as a means of child protection, as a means of preventing children from being abused by individuals that Jehovah's Witnesses have already identified as being a threat to children, but who aren't necessarily being reported to the authorities. Watchtower has this restrictions policy that it assumes will deal with any kind of threat in that area, which we'll be coming to. But what about if elders ask the branch office whether they can remove branch-imposed restrictions? Look at what it says in paragraph 26. Again, this is a document that members of the public can access over the internet, so I'm being very careful to only draw your attention to material that you can access yourself anyway, and which Mr. Brady has actually referred to in his opening statement. In paragraph 26 it says, if decades have passed since the wrongdoing, there is no outcry from the victim or the victim's relatives, and the individual continues to manifest a good attitude and qualifies in every other way, a letter approved by the Service Department oversight will be sent confirming that minor privileges may be extended gradually. This will allow the elders to see more clearly how the congregation and perhaps the community view him. So Shane Brady is referring to this as part of the policy document, the policy canon, if you will, that Jehovah's Witnesses can be so proud of. And here it's giving instructions that in some cases branch-imposed restrictions can be lifted so long as, number one, decades have passed, and number two, there has been an outcry from the victim. How is the victim to know that they need, well, first of all, what is an outcry? And how is the victim to know that they need to maintain an outcry for decades if they want to prevent the individual from getting any privileges, if this is a policy provision that you can literally only read if you are on the the service department or working in the service department of the branch office. This is exactly what Richard Scurrow was talking about earlier in the hearing about accessibility. It's not just about having a policy, it's about how accessible is that policy. Is everybody on the same page in understanding what all the rules are? If you are holding back some parts of your child sex abuse policy, then how is it anything to be proud of?
In concluding, there are three aspects of that policy that I would like to just briefly touch on, and again, which I believe responds to the broader issues that the inquiry is addressing. The first aspect is prevention. Of course, the best prevention is education and limiting the opportunities for abuse. Well, for decades, we have endeavored to address both of these issues, as I've touched on earlier. One, by providing a variety of educative materials to assist parents in educating their children on the crime of sexual abuse. Also, we don't sponsor any activities that separate children from their parents, and as a result, it minimizes the opportunities for abuse.
So he's not just, again, pinning it all on the parents and saying, oh, it's the parents' responsibility to prevent their children from being abused. He's also repeating his lie, and yes, Shane Brady, it is a lie, because you know that it's not true. He's repeating this lie that the organisation doesn't sponsor any activities in which children are separated from their parents. What about field service meetings? What about arrangements for elders to arrange Bible studies with children of believing parents? And what about the baptism questions? To cite just three examples, it simply cannot be said that this is an organisation that does not separate children from their parents. Indeed, as I mentioned earlier, the story of PRA 5 demonstrates in a very horrifying and tragic way just how readily the arrangements that witnesses have as part of their regular worship can be exploited by pedophiles so that they can get access to children.
The second key aspect of our safeguarding policy is how we respond to allegations of abuse. Now, our current policy makes it clear that anyone who learns of an allegation of child sexual abuse has the absolute right to immediately report it to the statutory authorities, and no one should discourage them from doing so.
That is indeed part of the existing policy, and I welcome that wording, but it doesn't go far enough in an organisation that for decades has told witnesses that it's wrong to take your brother to court and it's wrong to insist on your personal rights. This was highlighted as recently as the February 2018 Watchtower, in which Jehovah's Witnesses were told that taking a brother to court or insisting on one's personal rights was characteristic of quote-unquote fleshly minded people. So it's one thing, again, to have it written down in your policy. What does the culture say? What's the culture of the religion? What are the beliefs? What's the ideology? How will this instruction be interpreted by people who have been raised perhaps in a culture where it's wrong to follow through on your rights even if you have that right?
But our policy also directs that when congregation elders learn about an allegation of abuse, they must immediately telephone the Britain branch office to ensure that allegations that need to be reported to the statutory authorities are reported to the statutory authorities. In addition, if a child is in danger of abuse, the elders will be directed themselves to make the report to the statutory authorities, even if there is no statutory duty to do so. If I could underscore that, if a child is at risk of abuse, the elders themselves will be directed to report it, even in the absence of a mandatory reporting law. Thus, any suggestion that we have a culture or rules that prohibit reporting abuse, or that we ostracize those who report abuse, we submit is simply not true. It's false. In the Republic of Ireland, there is a mandatory reporting law, and Jehovah's Witnesses fully comply with what the law requires.
There's a few things to unpack here. Shane Brady mentions the Republic of Ireland. On this channel, we did a Watchtower in Focus episode about what happened in a certain congregation where the London branch sent out a bunch of elders tasked with reviewing the qualifications of elders in a certain congregation who had gone ahead and reported a pedophile to the authorities without being instructed to do so by Watchtower. And according to newspaper reports, 2 elders were stripped of their duties, were in fact punished for reporting in Ireland. So it's interesting that Shane Brady should cite Ireland as an example of a country where there is mandatory reporting and therefore the organisation follows through with reporting abuse, when he should be well aware that this happened in this congregation. As for his claim that it's not true that those who report are ostracised, this is a half-truth. He cannot say emphatically that nobody who reports abuse is ostracised in any form. There are gradations of ostracism, from ordinary witnesses in a congregation viewing someone as bad association, to someone being disfellowshipped or disassociated. And I am certain that out of all of the cases that Watchtower will have dealt with, there will be at least some where an individual has ended up being shunned themselves for pursuing justice, for reporting their abuse. If Shane Brady wants to make emphatic statements to the effect that no one in the Jehovah's Witness religion who has ever reported abuse has ever been shunned, what he needs to do is present the records to back up that claim. I doubt he's going to do that. And also, I hope you'll notice his very clever wording where he talks about the procedure for making sure abuse is reported, even if there is no mandatory reporting, so long as the child is in danger.
If a child is in danger of abuse, the elders will be directed themselves to make the report to the statutory authorities, even if there is no statutory duty to do so.
He says, look, children who are in danger, if that's the case, of course elders will be allowed to report. What he is overlooking is that the branch dictates whether elders can report or not, and the branch decides whether children are in danger or not. He is saying in front of the inquiry, when children are in danger, we will report. But what he's not making clear is that it's the branch, it's the service desk personnel who get to make that call. And the entire point of myself and the other ex-Jehovah's Witnesses who were involved in this inquiry is to say, look, it should be the police who make that call. Any other arrangement where you have an organisation taking it upon itself to decide whether children are at risk, or to decide whether someone accused of pedophilia is a threat to a congregation, is effectively overriding the jurisdiction of the authorities and doing the job of the police and social services on their behalf. That is self-regulation, and that cannot be allowed to continue.
After ensuring allegations are reported to the authorities, the elders will then provide pastoral support to the victim and the victim's family. And that pastoral support, as part of the family focus of Jehovah's Witnesses, will be to pray with and for the victim, to read comforting Bible passages that, for Jehovah's Witnesses, will provide comfort and hope and strength to them. But the elders are not health professionals. They don't purport to be so. And they will remind the victim and the victim's family of the need for them to decide, to consider obtaining professional support.
The elders are not health professionals, but yet here they are involving themselves in pastoral support without any formal training in how to deal with child sex abuse victims, in what to say to them, in what not to say to them. The only training that elders receive is from other elders, is from the organisation. And yet apparently the inquiry is supposed to be impressed with this procedure for pastoral support. And what I find disturbing is when you open up the Shepherd book and read chapter 14, where it deals with pastoral support, it almost seems to suggest that pastoral support is the priority over seeking professional help. I, and presumably many of you watching this, would argue that the priority is professional counselling when someone has been subjected to child sexual abuse. And if the person wants to also have pastoral support from untrained elders who haven't had formal qualifications or formal training in how to deal with abuse victims, no one can stop them. But suggesting that pastoral support is the priority is clearly putting the cart before the horse.
The third key point I would like to emphasize of our policy is this. If the offender is not expelled, and that's a religious issue, or if a person who has that history wants to become one of Jehovah's Witnesses, the branch office will impose strict restrictions on the offender. Those restrictions remain in place indefinitely, and they will follow the offender even if he moves to another congregation. In most cases, an offender would be expelled. But even if he's not, those restrictions apply in all cases, not just to an elder, to a faith leader, but to anyone who has committed the offense, even including a congregant, or other religions refer to as a lay member or a parishioner. Among those restrictions are these. The offender will not qualify for any responsibilities, duties, or tasks in the congregation for decades, if ever. Secondly, the elders will meet with the parents of all minor children in the congregation and any others that may move in afterwards to specifically warn them that their children should never be left alone with the offender. They will also direct the parents to specific material we have published on protecting children from abuse. Now, those are in addition to restrictions that the statutory authorities may impose.
So I've already mentioned this whole restrictions business, and I find it fascinating that Watchtower is so proud of this aspect of their policy. First of all, I just want to comment on or observe where Shane Brady says, in most cases, an offender will be expelled. Well, again, if you're going to make an absolute statement on that, what you should be doing is presenting the statistics and presenting the records and letting the inquiry see for themselves whether that's true or not. To make an absolute statement of that nature without providing supporting documentation is essentially, again, marking your own homework and asking the inquiry to take things at face value, apart from the fact that it's also ignoring the fact that when someone is disfellowshipped, they are allowed to, after a number of months, get reinstated. So they come back into the system. So simply saying, in most cases we expel child abusers, doesn't cut it if you allow them to come back in a few months later. You have exactly the same problem. You're just kicking the problem into the long grass when you disfellowship them, potentially. But as far as the restrictions policy itself is concerned, I've already shown you the S66 form, where it says that after decades have passed, and if there is no outcry from the victim, some restrictions can start to be lifted. And again, victims, ordinary victims and ordinary members of the congregation don't have access to this part of the policy when it comes to restrictions. When it comes to notifying parents in the congregation about someone who is known to be a child abuser, clearly I welcome that policy, but it doesn't go far enough, because what happens if, for example, an elder visits the congregation on a Sunday to give a talk, he's visiting from another congregation with his children, how is he supposed to know that someone in the congregation is a child abuser? Same thing if a member of that congregation is visited by their believing family who happen to have children. How are they supposed to know that their children are in danger? And what happens when you have conventions and assemblies and all of the congregations are mixed together? How does this policy of warning parents in a particular congregation help in that situation. Simply put, the restrictions policy is not fit for purpose. It puts a burden on elders that they can't possibly live up to. It effectively enlists elders as a makeshift police force who are tasked with monitoring a pedophile indefinitely, potentially for many decades, or at least until that person moves to another congregation. Elders are being expected to monitor an individual's behaviour whenever they're involved in their worship and coming into contact with children. Expecting volunteers to do this is clearly unfeasible, and part of the restrictions policy also involves sitting down with the known pedophile and telling him or her, don't you do anything that brings you into contact with children, which again amounts to self-regulation. The pedophile is being asked to police themselves. That's the restrictions policy. It's clearly inadequate and not something for Shane Brady to be jumping up and down about.
Once those steps are cared for, what happens next? Well, child sexual abuse is not only a serious crime, but for many religions, and certainly for Jehovah's Witnesses, it is a gross sin before God. So when child abuse has been committed, the elders will then determine, after the steps I've outlined are cared for, whether the offender, if he's one of Jehovah's Witnesses, whether he should be excommunicated, expelled, or disfellowshipped, as Jehovah's Witnesses will refer to it. What is the role of the victim in that ecclesiastical process? Elders will receive information from the victim, if the victim's an adult, or from the victim's parents, if the victim is a child, about the allegation. That information can be provided in writing or in a private session, as the victim feels comfortable with. The adult victim can be accompanied by a mature confidant. But the elders do not require the victim to confront the offender in that ecclesiastical process. Well, ultimately, the elders will decide based on scriptural doctrine and standards whether the offender should be expelled. And so we respectfully submit that whether an offender is expelled and the religious process that elders follow to make that determination is in that sense, it's beyond the scope of the issues this inquiry is examining. It is strictly a religious process.
This goes back to what Richard Scorer was saying before about religious freedom and organisations effectively saying, mind your own business. We're a religion and we get to decide what religious practices we have. Shane Brady here effectively saying, look, we get to decide whether we disfellowship a pedophile or don't disfellowship a pedophile. It's not within the scope of the inquiry to suggest any kind of regulation on that activity. But again, he's ignoring the fact that a disfellowshipped pedophile can get reinstated and just circulate back into the system. And the reason they can do that is because Jehovah's Witnesses consider child sex abuse to be something that you can be sorry for. Now, Mr. Brady was also talking there about the degree to which victims are involved in the judicial process. He stresses that victims are not required to confront their abuser. Again, it's fantastic that that's now part of the policy, but what is the organisation going to do in terms of redress for all of the victims in past decades where they made the victim confront the abuser, where they effectively twisted the knife and exacerbated the pain and abuse by putting a victim in that situation where they had to confront their abuser? What is the organisation going to do about that, about the legacy of that particular practice that we know through multiple reports, including the findings of the Charity Commission when they investigated the New Moston congregation? Multiple reports attest that this has happened. What is the organisation going to do about it? And finally, I don't think the inquiry should take too kindly to this idea of victims being expected to involve themselves in the judicial process at all. Because if you think about it, what is the judicial process? What's it for? Someone who is processed judicially is processed to, number one, give them spiritual assistance and try and heal their relationship with Jehovah, and number two, keep the congregation clean of a sinner. Now, if you want to keep a congregation clean of child molesters, it's very simple. All you need to do is report them to the authorities and defer to advice from the authorities on the extent to which children are in danger in that community. So that nullifies the first reason for involving abuse victims in a judicial process. What about the second, that of restoring the child abuser's relationship with Jehovah? Well, why is that something that child abuse victims should be expected to indulge in? Why should they be recruited into a process that is aimed at helping their abuser? How is that any of their business, and how is that a reasonable expectation? It doesn't matter if you're saying, oh, well, they can do it by telephone, oh, they could do it by writing, they could do it by WhatsApp message. I don't care what arrangements you're making for them to be involved in this process. The simple truth is you're asking them to be involved to help their abuser, to help the perpetrator, not to help them. An easier way around the whole situation is to defer to the authorities. Did this abuse happen or didn't it? Oh, this individual's been convicted criminally by the authorities. Never mind, we don't need to hear from the victims. He's disfellowshipped. That's all they need to do. But they don't do that because they insist on the two-witness rule. They insist on doing things as they consider the Bible to command.
Well, Chair and members of the panel, we look forward to the opportunity to assist this inquiry in this investigation and to provide accurate information about our child protection policy, practices, and procedures. Thank you.
Thank you.
Well, I'm not sure that Mr. Brady has provided accurate information. A lot of what he's said is half-truths and evasions, red herrings, intended, it seems, at throwing the inquiry off the scent and distracting them from the main issues. And on a couple of occasions, he goes as far as to outright lie to the inquiry by telling the inquiry that Jehovah's Witnesses do not have any practices that serve to separate children from their parents, when, as I've mentioned, there are a number of practices that do just that. So I don't know what you'd be thinking at this point if you're a Jehovah's Witness watching the evidence, and by all means, don't just take my word on things. Don't just listen to what I have to say. You can, if you want, watch the unabridged version of this video. It is on YouTube, and I will provide a link below. I will also provide a link to the transcript so that you can go through and see. Perhaps if you're hard of hearing, it might be better for you to go through the written version of these hearings. But in any case, I don't see how the organisation looks good here. They've gone into this proceeding with nothing but denialism and arrogance, which, when contrasted to the approach taken by other religions, like the United Reformed Church and the Methodist Church, it just does not look good. It doesn't look respectful, going back to what I was saying earlier. It doesn't look credible. What Shane Brady has effectively done is lie down in the chalk marks that Richard Scorer and Samuel Barker sketched out for him. He's done exactly what they predicted he would do, which is say that everything's fine, nothing to see here, move along, folks. That is not the attitude that Jehovah's Witnesses should be taking when it is so blindingly obvious at this point that there is a problem with its child protection practices. So those were my thoughts. We got there eventually. Those were my thoughts on the opening statements from the IICSA hearings. Again, these hearings are postponed, so I don't know when you can expect to watch part 4, which will be, I guess, the hearing in which I will appear along with other ex-Jehovah's Witnesses and hopefully PRA 5. and Paul Gillies. So there's so much to happen yet in these IICSA hearings, and it's going to be fascinating to see how it all pans out. I look forward, for my part, to doing whatever I can to help the inquiry get to the bottom of this and understand what all the various nuances are and all the ways in which Watchtower could conceivably lead them down a dead end. But we'll see how things pan out. I hope you have enjoyed my comments, and don't forget to subscribe to the John Cedars channel for more such videos, and as always, thank you for watching.